bring in now my legal analyst guest, joining me from Cleveland, Ohio, just north of Akron, criminal defense attorney Ian Friedman. Ian, always great to see you and have your expertise. What did you think of Michael Stefanko's testimony, please?
Well, this has certainly taken the case and off the rails a little bit. Watching it over the course of the week, watching today, it feels a little, if there's such a thing as roller coastery, and that's kind of the way it felt.
Right.
We always like to start a case with our theory. We hope it holds that way, and this is anything but.
Yeah, it really got off track, and I was a prosecutor. I teach trial advocacy, and I felt like the prosecutor's questioning of him was a mess. That trial transcript will be a mess. There were so many compound questions there, and defense counsel wasn't objecting. So I was really getting upset at the form of the questions, and then the fact that there weren't any objections being lodged. And I'm being told by my producer we need to go back in, Ian, so hold your thought on that one, please. Let's watch.
Two things I want to note for the record before we take our recess. And thanks, Desiree, again. Okay, so it's 5 after. Well, now it's about 7 after 12. You heard me tell the jurors they'll be back by 1 o'clock. We know that the state of Ohio is rested. Again, I just want to reiterate that you folks will be able to present all of your exhibits. We'll talk about all that. We'll talk about admissibility. Attorney O'Brien, you can either make your motion now, or if you would like to reserve your right, I will certainly hear it at the appropriate time your request to reserve is granted. I'd like to just have an idea as to what's going to happen this afternoon, or do you need to take the lunch hour to decide?
Judge, just inquired with my client, and at this point in time, it is Ms. Stefanko's wish to testify in her own behalf this afternoon, beginning at 1 o'clock.
Okay. I appreciate that. Go ahead.
If I could.
Mm-hmm.
I told Ms. Stefanko that she has a Fifth Amendment right. She cannot be compelled to testify. She can remain silent. I told her that there are risks, mainly cross-examination, whenever someone testifies.
Mm-hmm.
She indicates that she understands these. We talked about it at length last night.
Okay.
Your Honor.
Mm-hmm.
And even though she had indicated for months and months that she did not want to testify, and earlier in the week she said that she now decided she changed her mind and she would testify. I would ask the court to inquire. Okay.
And you answered any questions that you have. I understand, just like what you've indicated, for a certain period of time she indicated that she had no interest. She then apparently changed her mind. You've had those discussions with her. You've reviewed all of her rights to testify, not testify, the fact that there can be no comment on her not testifying. You covered all of that, correct?
Correct, Your Honor.
Okay. Did you cover with her the fact that it is not necessary that she take the witness stand in her own defense, that she has that constitutional right not to testify, and the fact that she did not testify must not be considered for any purpose by the jurors, and they will be instructed on that?
She understands that, Your Honor.
Okay.
For the Fifth Amendment.
Fair enough. And then she also understands, in addition to what you talked about with her, that if she chooses to testify, her testimony would be weighed by the same rules that apply to other witnesses. You explained all of that, correct? Yes. All right. And you're asking me to inquire of her at this time?
If she is doing this voluntarily and intelligently.
Okay, thank you. All right, Ms. Stefanko, you've heard just all of the discussions that I've had with Attorney O'Brien on the record, correct?
Yes, Your Honor.
Okay. And you heard Attorney O'Brien indicate that for a period of time you made statements that you did not want to testify. Is that correct?
That's true, Your Honor.
Okay. And now you've recently told your lawyer that you, in fact, want to testify on your own behalf. Is that correct?
That's correct.
Okay. You understand that you have a right to not testify, and the fact that you don't testify cannot be used against you. You understand all of that?
I do.
The state of Ohio would not be allowed to comment on the fact that you did not testify in their closing arguments or even make any mention of that to the jurors. Do you understand that?
Yes, I do.
You understand that, and Attorney O'Brien has explained that he went over with you the fact that if you do take the witness stand, you'll be subject to cross-examination by the state of Ohio, and there are a variety of matters that they can cover with you. Do you understand that?
Yes, Your Honor.
Okay. Has he answered all of your questions as it relates to your decision to testify or to not testify?
He has.
Do you have any questions for this court at this time?
No, Your Honor.
Okay. With that, though, I appreciate the fact, Attorney O'Brien, that you've had that discussion. It sounds like you've had multiple discussions with her about each perspective. One more time, though, over the lunch recess before 1 o'clock, I'm going to ask that you talk to her just finally, and then I can confirm with her also. And I'm sure you have and will discuss the risks of her testimony in the event that she decides to go under oath in front of these jurors. Correct?
It will be done, Your Honor.
All right, thank you. Then, Ms. Stefanko, anything else that you would like to address with me, only specifically related to your choice to testify at this time?
No, Your Honor.
All right, have a seat. Does the state have anything that you would like to put on the record about what we've just discussed, or do you believe I need to advise the defendant about any other issue or inquire in any other manner at this time?
The only thing, Judge, is just as Mr. Tong was instructed regarding spousal privilege, I would ask that she be instructed about the same thing.
Okay, fair enough. And as it relates to the prior rulings that I made, those rulings will stand. But specifically, though, I want to address with you as it relates to the advisement that I just gave her in the interaction I just had with her. Anything else you believe it's necessary for me to inquire?
No, I believe you covered it all.
All right, thank you very much. So we will take a lunch recess. And right now, is there anything further that the state of Ohio would like to put on the record?
No, Judge, thank you.
Okay. Attorney O'Brien?
Nothing further at this moment.
All right. So what I would like, I told the jurors, I think, 1 o'clock. If you folks would report back here at 5.
Wow, some big breaking news. Erica Stefanko wants to take the stand and testify on her own behalf. I want to bring back in criminal defense attorney Ian Friedman, standing by in Ohio. Ian, do you think she can help herself?
Well, Court TV viewers are getting to see something that doesn't often happen. It's not like, the hour programs where every defendant testifies. There's a reason that we usually don't have our clients testify. There's a lot of downside here, but this trial's been all over the board. Hard to predict. Found it interesting that defense counsel made it clear that there were discussions about her not testifying, and now it's changing. Who knows? It sounds like that we're all in for a surprise here shortly.
You're right. Like you said earlier, this trial has been like a roller coaster, and perhaps the best is yet to come. Ian Friedman, always great to talk with you. Thank you so much. We're going to take a break. When we come back, it is your daily sidebar here on Court TV. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, and this is your daily sidebar. Wow, we just heard about some breaking news moments ago that defendant Erica Stefanko is set to testify on her own behalf. She has every right to sit there, say nothing. The jury cannot hold that against her. The defense has no burden at all. The whole burden lies with the state of Ohio in proving these allegations against her, but she's making the choice to get up and share her story. So I want to bring in my colleagues and see what they think about this. Michael Ayala and Ted Rollins are joining me now. Michael, I'll start with you. What do you think of this decision by Erica Stefanko, and can she possibly help herself by testifying?
Well, okay, it's a compound question, but I'm going to answer it. She can help herself, right? Because I feel like I've done informal surveys, right? It's one of the things we do around here in the newsroom, including you, Julie Grant. And most of the people I spoke with, there are a couple who think that the prosecution has met their burden. Most don't. That in and of itself, the fact that there's disagreement suggests there might be reasonable doubt here. I think the defense attorney feels that he's got some reasonable doubt here, which is why I think he wanted to get on the record the fact that they've had these conversations. I see that he is trying to convince her not to take the stand. I think he thinks he has enough. I think there's reasonable doubt here. And I think by getting on the stand, she can only hurt herself. But if she's adamant about doing that, it is her right, and we'll have to see what happens.
Okay, so if it were you, you would say let's just go with the reasonable doubt that exists now, take our chances. Of course, the right lies with her. The attorney can advise her all day long, but at the end of the day, it's her decision. But I hear what you're saying. You think there's enough reasonable doubt that the defense could be successful here and win. Ted, what do you think about that, about the point Michael made, the reasonable doubt, and then what's your reaction to her wanting to testify?
Yeah, there's a reasonable doubt, but I do think that right now there's a very good chance they come back with a guilty verdict. And if she takes the stand and she has an actual explanation of what happened that night that's plausible, believable, all kind of better than the other one, then she's golden. There's already some reasonable doubt. If she can get up and say, yeah, I made the call to the pizza place, but it was because of a meeting that I thought was just going to, be between those two to hammer out the child custody issues. I had my kids with me. I mean, did I think there was going to be a murder? Are you kidding me? No. And then once there was a murder and I saw it was covered in blood, I was petrified. I was there to just take care of my kids. Now it makes sense. That's possible. And I think she walks.
Right. I'm with you. My take on it is, generally, and I'm sure you gentlemen both agree with me, generally defendants don't help themselves when they testify, but sometimes they do. And I've had cases, I've been on the losing end of some cases as a prosecutor where they have, and not one as serious as this one, I will say that, but sometimes a defendant's testimony can be beneficial to a judge, to a jury. And here, I think because Chad's story was so vague, where he needed to be specific, it lacked specificity. And I blame the prosecution for that. They should have asked him specifically exactly what he did and what she did. And where I think the biggest opening is for the defense to move forward and solidify her innocence is that Chad admitted that the two of them did not plan this murder together. Michael, your thoughts on that fact, please.
I agree with you, but I think there was a reason the prosecution pulled back on the specificity. I think it became clear, and again, we talked about this before, Julie, where I felt initially it seemed like he wasn't as well prepared as you thought he would have been by the prosecution, but I don't think that was the prosecution's fault. I think this guy has gone off on a whole nother thing. I think the prosecution realized that during questioning. I think they cut it short. I said, you know what? The deeper we go into this guy's story, the more surprises we're going to get. Let's just stay with what we have. And I think they just decided to go with that, thinking that maybe they had more. They had her own voice on tape. They also had GC testifying about what she heard. Maybe they thinking that was enough. So as far as that goes, I agree with you, but I think I changed my feeling over time now that I see where he went, not only on the rest of direct, but also on cross.
Ted, how do you think she needs to come off for this jury? What do you think they're going to be looking for and wanting to hear from her?
Well, she can't lie, and I just can't believe she didn't make that pizza call, because that it doesn't make sense that she didn't. Who else did? Mama Cobb? I doubt it. So if she embraces the bad facts and she embraces that she made that call, I think she just has to be honest, because that would be then the truth. I don't think she knew that Ashley was going to be murdered that day. It doesn't make any sense. Why were the kids there?
Right. She absolutely has to own that call. She has to be apologetic, sympathetic. But then I think where she has an opportunity to explain is in what she knew at the time of the call. If there was no plan in place, I think she is going to walk. Ted, Michael, thank you so much. Court TV Live continues right after this. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, and just in a couple moments from now, we're set to hear defendant Erica Stefanko take the stand and testify on her own behalf in the pizza delivery murder trial. She's being accused as being an accomplice to her then-husband, Chad Cobb. This guy's already been convicted of the murder of Ashley Biggs, and now Erica Stefanko is married to someone else, a man named Michael Stefanko, and he testified just a short time ago. I want to show you a clip of something. The prosecution was exploring an area where they were saying he violated an order put in place by the court. Let's take a look back at that testimony together now.
So you're saying you were not aware that you were not supposed to look at, watch, Google, Facebook, or watch Court TV live stream this trial. That's what your testimony is right now.
That's what I'm saying, ma'am.
And you did that. Isn't that correct?
Yes.
Did you watch the whole trial?
No.
What parts did you watch?
I watched the opening statement of both the prosecution and the defense.
Did you watch Chad Cox? And you're saying that's the only part you watched?
On one other occasion, I watched the court TV preview of what happened that day.
And what happened that day? Did you see Chad Cox's testimony?
They talked about his testimony.
And isn't it true that you spoke to the defendant, Erica Stefanko, on the phone about the testimony?
No, there was no direct discussion about Chad's testimony.
Just last
I was asked if I had watched any of it, and I told her I had, because I wanted to know what she was going through in this courtroom.
Isn't it true that she told you should watch Chad's testimony?
No.
She didn't tell you, she didn't urge or encourage you to watch Chad's testimony?
No.
When you said the court TV was recapping Chad's testimony, did they show his face or have him up on the screen, or were they just commenting on it?
They showed his face.
And then that's how you were able to see his hair, and you two were joking about how he looked on there?
Correct.
All right, I'm going to bring in now my legal analyst guest to help me break this down. Still with us, criminal defense attorney Ian Friedman. Okay, Ian, so watching this, what jumped out at you with what the prosecution was trying to make with their point, what perhaps was conveyed to the jury or what was lost on the jury, and then who has any responsibility in this when it comes to that separation of witnesses?
Right. So in any trial, there usually is a separation of witnesses. And really what that means is you want every witness to take the stand, testify to what he or she knows or doesn't know, and you don't want it tainted by any other testimony. That's why we keep everybody separate. So in this case, the gentleman on the stand, the current husband, was being called by the defense. There certainly would have been a request by the parties in the court ordering separation. And what we usually do is we tell all of our witnesses, look, there's a separation order. You can't talk to other witnesses. You can't watch the trial. You can't be in the courtroom. Because, again, we're trying to make sure that when they get on the stand, everything that they say and do is simply theirs. It wasn't affected by anything that was said previously. So is there responsibility on the defense lawyer if, in fact, this witness was not advised of the separation order? Sure. In answer to your question, there's more to it, but I think that specifically answers that.
Right. No, I appreciate that. And just an educated guess here, I want to see if perhaps you agree with me.
Yeah.
How did the prosecution know about this? My best guess would be that they're probably listening to the jail phone calls that Erica Stefanko is making, going out, coming into the jail. They're recorded. My guess is they were listening in and caught this conversation. Any thoughts on that? Because otherwise I don't know how they would have known whether Michael Stefanko was in his house watching court TV.
Exactly. First off, it was great press for court TV. I was counting the number of references to court TV, and it's riddling the transcript, which is fantastic. But, Julie, I agree with you 100%. It came from the jail calls. We always tell our clients if they're in jail, do not talk on the phone. A, it's recorded, and B, the prosecutor is going to listen to it. Now, what surprised me from the cross-examination by the prosecutor was that when the prosecutor said, well, didn't the defendant encourage you? Didn't the defendant, basically suggesting that there was this discussion between the defendant and this witness and that they were kind of concocting what he should do? When he said no, usually if you're going to ask that question, and it's a pretty bold assertion, I was expecting them to play the tape and then impeach this witness and say, okay, well, that's not exactly true. We have the recording. So I was a little surprised it stopped short. But I agree with you 1,000%. Would have had to have come from the jail. That's usually how we see it.
Right, and you made a great point there with that impeachment. I mean, wouldn't that have been a moment if they would have played that then for the jury, if in fact there was something different on the tape? And if they had that information, if they had a contradiction and didn't share it, then shame on them. But I guess they didn't. I would hope that surely they would share that and impeach him if they had the opportunity. Great point, Ian.
Because talk about blowing his credibility out of the water. I mean, that's the best sort of evidence anyone could have. When they're under oath, they say, no, I didn't do this. Okay, hit play, and everything you just said went out the window. But that didn't
You're
happen.
absolutely right. Yeah, impeachment, that's some of the most fun you can have in a courtroom, really, it is. I want to play another clip for you, please, Ian. I want to get your reaction. This is a clip from Michael Stefanko's testimony, and he's talking about how Chad Cobb used to threaten Ashley Biggs. Let's watch.